Emma Mijas died a horrible and painful death unnecessarily on her very first Christmas Eve 2004 at the hands of 25 doctors and nurses, another victim of medical malpractice. All 25 doctors and nurses systematically administered the wrong drugs for her life-threatening condition called SLOS. SLOS, Smith-Lemli-Optis syndrome, is a congenital abnormality which requires treatment strategies on supplying supplemental cholesterol. They gave Emma the wrong drug, Questran, not once, but 92 times. Yes, 92 times in 1 month. A cholesterol-reducing drug, not the cholesterol supplemental drug she needed. All of them knew better. They were trained to know better. They were some of the world's leading authorities at the Louisiana State University Health Science Center in New Orleans. But they just didn't give a damn about Emma's life. In 2013, the prestigious Journal of Patient Safety published a study that as many as 440,000 patients die each year from preventable medical errors. That would make medical errors the third leading cause of death in America, behind heart disease and cancer, which is second. These people are not dying from the illnesses that caused them to seek hospital care in the first place. No, they are dying from mistakes that hospitals could have prevented. What are these fatal errors? Who are these incompetent and negligent doctors? A New England Journal of Medicine, January 28, 2016 study reported that 1% of physicians accounted for 32% of paid malpractice claims over the last 10 years. The ugly truth is that little is being done to hold these dangerous doctors accountable. Researchers found that bad doctors showed distinctive characteristics, including having paid previous malpractice claims. So it stands to reason that healthcare providers could eliminate 1/3 of medical malpractice along with patients' pain and suffering, as well as the added cost of corrective surgeries, long-term care, and indemnity payments by removing the worst 1% of doctors. Why aren't bad doctors stopped from practicing? The answer lies, at least partially, in the National Practitioner Data Bank, a clearinghouse for information on medical malpractice that Congress established in 1986 to help state licensing boards police the healthcare industry. The national database was supposed to help states identify dangerous doctors and prevent them from harming more patients, and is used by hospitals, insurers, and licensing boards to track doctors' records, check prospective hires, and make other decisions. But it is virtually useless in holding doctors accountable because, by federal law, none are listed by name. They are assigned a random number to protect their identities. Even if doctors were identified in the data as they should be, the public would still be barred by law from accessing the records. So vulnerable, sick patients sit in the waiting rooms of bad physicians without a clue about their poor record of performance. And in many cases, a negligent doctor's insurance company pays the victim of malpractice and the doctor goes back to work. If a doctor develops a bad enough reputation in one town, he can move to a new state and continue practicing. This is unbelievable. But today, the public does not have access to the database to identify doctors' names and addresses, to identify doctors with uniquely long histories of being sued or disciplined for medical malpractice. Because on September 1st, 2011, the government cut off public access. What was behind that decision? Apparently, one Kansas doctor with a trail of malpractice suits, Dr. Robert Tenney. The Kansas-based doctor complained to the Government Health Resources and Service Administration that the Kansas City Star newspaper was publishing the story of one of his patients, Mary Beth Chase, who died in 2007 after undergoing a brain surgery with Dr. Tenney. It is also noted that Tenney has been sued at least 16 times for medical malpractice, but had never been disciplined by the state's licensing boards. The Insider Exclusive produced a TV story on this case with the lawyers who represented Mary Beth's family when doctors go bad, Mary Beth Chase versus Dr. Robert T. Tenney. Tenney finally settled the Chase family's wrongful death suit for $1 million. The settlement brought total malpractice payments paid on Tenney's behalf since the early 1990s to roughly $3.7 million. In some states, including California, Colorado, Georgia, and New York, patients can go to medical boards' websites to find out about doctors' malpractice histories, but not in Kansas and Missouri. Why don't doctors report on bad doctors? Physicians often see the mistakes made by their peers, which puts them in a sticky ethical situation. Should they tell the patient about a mistake made by a different doctor? Too often they don't. Why not? One reason is that doctors depend on each other for business. So a physician who breaks the code of silence may become known as an informer or snitch and lose referrals, a financial penalty. Doctors also may be wary of becoming entangled in a medical malpractice case or causing a colleague to face legal consequences. The bottom line, too often doctors aren't learning from errors, nor are patients getting the information they need to receive proper treatment or compensation when the outcome is harmful. In this Insider Exclusive Network TV special, Justice in America, Karl Thomsen's story, our news team visits with Aubri, Sheremet, and Stephanie Hoffer as we take you inside today's legal system, examining their strategies and their clients' thoughts and in vivid detail, showing you the often heartbreaking stories of cases like their client, Karl Thomsen, who they successfully won a $836,000 verdict for his family against Dr. Michael A. Nizzi. This was not an easy case to win, particularly in Grand Traverse County, Michigan, where a medical malpractice case has not been won in the last 23 years since 1997. So this $836,000 verdict against Dr. Michael A. Nizzi was a monumental victory, not just for their clients and their firm, but for all citizens of Grand Traverse County. This is the Insider Exclusive, live from Grand Rapids, Michigan. It is my great pleasure to introduce Aubri, Sheremet, and Stephanie Hoffer to the show.
Thank you.
Thank you for being here. Tell us a little bit about your firm. What type of law do you generally practice?
Well, our firm, it's Stephanie and I are the partners, and we practice mainly medical malpractice. We started as a defense firm, and after a little while switched over to being plaintiffs, but we do a little legal malpractice. The majority of our firm is medical malpractice, wrongful death, personal injury, where we have a real connection with our clients, helping people when doctors make mistakes.
Now, Stephanie, you mentioned a little bit about the origin of your firm. How'd that come about?
So Aubri and I were originally medical malpractice defense attorneys at a large law firm here in Grand Rapids. And when we left to form a small firm, which we thought was more, would help us to better be able to serve our clients, we started out as a defense firm, and then we decided that since it was just us and we had more freedom and flexibility, we could do what we had wanted to do and represent patients instead of doctors and hospitals.
There is a time in every lawyer's life, not every lawyer's, but a lot of lawyers who were formerly defense attorneys representing, in your case, doctors, hospitals, healthcare workers, right? When they are sued for malpractice. There's a time that comes in your life when you say, you know, I want to help the people that really get justice, who had a mistake committed, so they can get some sort of compensation. Was there any particular case that you guys worked on where that epiphany came about?
I don't think it was so much one case, so much as the continual process of being a defense attorney was that you get a case in and you work it up. You work up the same way every single time. You're taking the same steps. And then more often than not, you settle it in the end. And whether that's always what's best for your client or not, it is just you taking these rote steps. And I think when we first left, we thought that we could practice as defense attorneys in a different way. And then it pretty quickly became clear that that's just the way a medical malpractice defense attorney has to be and has to practice in order to stay in business. And that's not the way we wanted to practice law.
And I think for me too, because I came from a little bit different background, I was a prosecutor before I started doing civil work. And so I've always, just the idea of justice, how can I help clients? When we started doing plaintiff's work, it just clicked for me too, from my background, that was really what I was supposed to do in terms of this is where we're finding justice for people.
Well, and medical malpractice, it's tort law. And the point of tort law is to deter future conduct. And that's an important aspect of it for me. And I think that, you know, in more modern times, that purpose of tort law has really been getting swept under the rug and swept away.
Right, because in these types of cases, and we've done medical malpractice cases all over the country, you know, and they have their corresponding caps, as you have in Michigan. I have seen more often than not that the doctors who are, I'll give you the numbers, roughly 3% of healthcare professionals, mainly doctors, commit roughly 1/3 of all the medical malpractice. So what that means is they're still out there butchering people, okay? So when you bring up let's say an insurance company ends up paying money to your client, what I've seen too often is the doctors are able to continue practicing. And more often than not, if they're really, you know, bad or incompetent on a regular basis, the medical review board will say to them, you know, maybe the grass is greener in another state. So if you turn your license in right now, you can honestly say when you go to apply for a license in another state, you've never been disciplined. I've seen that time and time again, which means they're shoving one state's problems into another jurisdiction, right? Have you seen that?
I don't know if we've seen that specifically. It certainly is something that we're aware of. Unfortunately, I think it is part of how tort law and how tort reform has come down in terms of...
Now, getting to the case that we're here for today, Karl Thomsen. Tell our audience a little bit about who Karl was.
Karl was just the everyman. He was a hard worker. He lived in Traverse City with his significant other. He worked hard as a respiratory therapist at the hospital there. He had 2 daughters that he loved very much, even though they lived out of state and out of the country. He saw them as much as he could. He had a new grandbaby. Before he passed, he got to spend some time with him. And he loved life. He liked to go out on his boat. He liked to play guitar. He was a hard worker. He was just your everyday person.
So what happened to Karl?
So Karl, and like Aubri said, he was a respiratory therapist at Munson Medical Center, who we ended up, where the surgery took place. He went to Dr. Michael Nizzi for an evaluation for bariatric surgery. Like all bariatric patients, he was obese. He was morbidly obese. He also had a condition that many obese people have, which is sleep apnea. Sleep apnea significantly increases the risk of surgical complications and healing. So Michael Nizzi didn't seem to pick up on any of that, even though a sleep apnea evaluation is on the step list, the checklist of steps that need to be taken before a patient can have bariatric surgery.
Was Dr. Michael Nizzi, was he aware that Karl had sleep apnea?
He should have been aware that Karl was very high risk for sleep apnea, and there were several stages where mistakes were made. So he should have sent Karl for a sleep study before he decided to perform this surgery, and he didn't. And on the checklist of steps, where it says sleep study, he wrote in his own handwriting, no.
Know that he hadn't had that test.
That he didn't need it. He was excused from having a sleep study. So fast forward, and during another pre-op evaluation, there was what's called a stop-bang evaluation done. And that is a test that assesses a person's risk for sleep apnea. And Karl scored as very high risk for severe sleep apnea. Dr. Nizzi still didn't send him for a sleep study. And what makes it so horrible is that having sleep apnea does not mean you can't have bariatric surgery. But once you are evaluated, you are put on a CPAP machine and you are given several weeks to adjust to the CPAP machine. And then you go and you have the surgery, and after surgery you are immediately placed on your own CPAP machine that is calibrated to you, that you are used to. So when Karl started having problems after surgery, started having trouble oxygenating and breathing, and they tried putting a CPAP on him, he was fighting it. He was, not with it because he was still under the effects of anesthesia, and he also was claustrophobic. So he wasn't able to tolerate the CPAP, whereas if Dr. Nizzi had done what he was supposed to do, Karl would have had the sleep study, he would have been put on a CPAP, and he would have been able to acclimate to it.
So the doctor really didn't evaluate him properly prior to surgery. That's what it comes down to, correct?
Well, Karl underwent the surgery. There are several things that had gone wrong, and one of the things was his failure to oxygenate. So he also, the issue with the sleeve gastrectomy and the Roux-en-Y in terms of what choice the doctor made. He chose a riskier surgery, so those things were compounding on top of each other. And Karl ended up having disastrous complications.
Initially he developed a leak, and leaks can happen, but he was at more risk of developing a leak because of his inability to oxygenate. So the tissue was not able to heal appropriately. That leak then went undetected, despite Karl getting worse and worse and worse. And a simple CT scan could have been done, which would have revealed the leak, and it wasn't done for 5 days after Karl started showing symptoms of a leak.
Karl had these additional complications. He eventually was released, went home. Unfortunately, he was diagnosed with leukemia, right? And he passed away. How did this case evolve and come to you guys?
So Karl came to us before he was diagnosed with leukemia, and like so many of our clients, the first words out of his mouth were, "I'm not the type of person that sues people. I never thought I would sue people." But he told us that as a Munson employee for 20 years, he watched our healthcare system and the quality of care deteriorate over time. And he felt an obligation to bring that to light.
With his case.
With his case.
You decide to take his case after some investigation, right? And then you get the bad news. The bad news is he's diagnosed with leukemia, right?
We got that bad news right before he was set for his deposition. So we adjourned his deposition to give a little time for him to start to feel better, get into treatment, and then we got a call that he had been hospitalized. And so we tried to get to the hospital, to get to talk with him, maybe get his deposition before he got worse, and then he was gone. He was gone within about 24 hours from us being notified.
So this case originally started out as a medical malpractice case, and it evolved to a...
We added a wrongful death component after speaking with several experts about the fact that his leukemia could not be treated because that leak that Stephanie had talked about, essentially that had reared its ugly head, and they were not able to treat his cancer.
Now, where this case was tried was Grand Traverse County, correct? Okay, and I understand that medical malpractice cases are generally never won, and you have the first case that was won since 1998, 22 years.
1997.
What is the significance of not only winning this case, but also the verdict you got was what, $836,000? Is that right?
Correct.
Okay. What is the significance of this?
The jury gave us every penny that we asked for.
Right. And because they were totally moved by the malpractice committed by Dr. Nisi, correct?
I mean, that was what the verdict stood for us. They did not find on the wrongful death claim, but on the medical malpractice claim, they did award everything that we had asked for on that.
What kind of message does this send to the people of Grand Traverse County about medical malpractice cases?
I think what it tells people in Grand Traverse County is they can have, faith in their doctors, they can have faith in their hospitals, but every doctor, doctors make mistakes, hospitals make mistakes, and when that happens, they need to be held accountable. And I think that that had not been shown to Grand Traverse County individuals. And we had gotten calls after our verdict of people saying, thank you for coming up here and trying this case and showing that hospitals and doctors do make mistakes and that they can be held accountable.
Right, and that's the important thing, because like police in civil rights cases, like doctors, like any industry, people like to stick together because they don't want to admit the mistakes. And it's very difficult to get other doctors, like in medical malpractice cases, particularly in the area that you're in, to testify against them, because financially, they won't get the referrals that you normally get if you stick together. So for our audience, these are some general questions. You got a lot of calls. I'm sure some of the calls didn't go anywhere. What is medical malpractice?
Well, a medical malpractice case, it is essentially if a physician has committed professional negligence, there is an injury, and then there's a causal link between that professional negligence and the injury. And to prove negligence, you have to show that the physician did something outside of the ordinary and reasonable care that's expected within their profession.
And not just physicians, but any healthcare provider.
I would guesstimate, as you well know, that when people, like, for example, die in a hospital, and I'm sure you've handled or represented people in that situation, that the doctors come out and say, we did everything we could, right? And there's a lot of people believe that, because people believe men and women in white coats, don't they? They're on the front lines, they're supposedly helping people, that's why they went into the profession. And that's what you're always up against with juries, because a lot of people, like Dr. Michael Nisi, has a great reputation, doesn't he? He did make a mistake because he's a human being. Everybody makes mistakes, but he was not willing to own up to it, and he thought he could beat you in court, but a jury saw otherwise, right? If you happen to be someone who thinks they've had medical malpractice committed against them or their family member or somebody, what are the initial steps that you should take? And along with that question is, you can subpoena medical records, obviously, okay? Can an individual get those medical records of their family relative easily?
I was going to say yes until you said easily, but because I think that it is difficult. Michigan requires providers, hospitals to turn over medical records to individuals, or if that person is passed, to a relative. Getting the medical records can be really difficult.
Yeah, and sometimes those medical records are altered. I'm sure you're aware of this. We've handled cases like that, where a lot of times I've seen doctors write on a Post-it, something that disappears when they go back and they look for the records, but that Post-it was the smoking gun, if you will, something they should have looked out for, but they didn't. Did you have experts in this case testify on your behalf?
Yes.
You did. And that medical expert, doctor, what area did they come from?
So we have a general surgeon, because Dr. Nizzi was a general surgeon. So in Michigan, we have to match specialties on standard of care. And then we also had Dr. Gluck, who was a pulmonary critical care physician.
What are the importance of medical malpractice cases? Why should these suits be brought, and what do they accomplish?
I think it's going back to what we talked about before in terms of the people in the community need to know the good and the bad about the hospitals and how they can choose hospitals and providers. And it just is essentially, it's holding hospitals and doctors and nurses accountable. If medical malpractice cases aren't brought or can't be brought, then there isn't a level of accountability. And it's knowledge. It's knowledge to the people in the community that people do make mistakes, but if a mistake is made, the individual will be held accountable.
Because of this case, I'm sure you've gotten increased calls for medical malpractice cases. How do you pick your clients? A lot of people call and say, hey, my rights were violated, my relative, wife, husband, brother, whatever, died as a result of medical malpractice. Where do you go from there? How do you evaluate that case?
Oftentimes, we don't get past an initial phone call with the client. Being a small firm, we're rather picky, but we need to feel for the client, the patient, in that first phone call. If within the first 5 minutes they don't have us, they're never going to have a jury. No, and then we look for serious injuries. Litigation is not fun. It is not a good process for any client to go through. So to subject a client to a medical malpractice lawsuit and litigation and the time that it takes and the costs associated with it, it should be reserved for serious injuries. And you don't want to put a person through that because, a doctor didn't take more than 10 minutes to treat a cut on their finger.
In the state of Michigan, there are caps, and let me explain for our audience caps. Tort reform, a term that was invented by the insurance industry, decided to try to limit the amount of money recoverable in all kinds of cases. It wasn't necessary at all because there's checks and balances built into the system already with appellate courts, with the state Supreme Court, etc., right? In the state of Michigan, what are those caps for medical malpractice cases?
Well, there's 2 caps. There's on non-economic damages.
Pain and suffering.
Right, a low cap and a high cap. So most cases fit into that low cap.
Which is what range?
In this year, changes every year, but it's about $483,000.
That's the low?
It's the low cap.
What's the high?
The high cap, you have to prove certain injuries. For example, if someone is a brain injury and they wouldn't otherwise be able to function.
And what would the high be then?
$815,000.
California, great blue state. We got a cap on non-economic damages, pain and suffering, $250,000. It's been in place for 45 years, excuse me. Now, what about economic loss?
No caps.
See, the problem with having caps, such low caps like in California, $250,000, it costs in a case like this to put it together about $100,000. So let's say you win the case, and let's say the client doesn't have any economic value. They're unemployed, they're a student, they're a senior, whatever. 40% of $250,000 if you win is $100,000, which is approximately what it costs to put this case on, with the experts, etc. Which means there's a lot of people left out of the legal system. They cannot sue, not that they want to sue. You brought up a good point. Most people who walk in said, I never thought I would sue anybody. They don't like suing people because there are friends and relatives that said, what are you doing? This hospital is a great place. I had my kids born, they were born there. I had my wife had surgery. It's a great place, and they're up against that too, aren't they? Any parting words about the case?
I think that if Karl had lived and he had been there and seen the jury return the verdict, I think he would have felt like justice had been served.
Well, I want to thank you both for being on the show.
Thank you.
Thank you.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.